This is George Washington. He may be known to some of you. Mr. Hamilton.
General Hamilton.
General Hamilton. My apologies. Mr. Jefferson and Mr. Madison. I've been asked to ask you a few questions, gentlemen. I hope.
I beg your pardon, dear?
Your mic's...
I sat on something.
No, my name is not Michael.
Oh, no, of course not, General Washington. But if you'd like to speak louder to the audience.
Oh,
Right
it's a
behind
newfangled
you.
contraption.
It's a newfangled contraption.
and it's called Michael?
Yes.
We're here tonight to ask you a few questions about the Bill of Rights, or the first 10 amendments to the Constitution. Mr. Madison, let me start with you. As you know, your proposal to add a Bill of Rights to the Constitution was greeted quite coldly by your fellow Federalists.
Indeed.
Most of them considered a proposal like this unnecessary and a distraction from really important issues like determining impost duties, establishing the federal judiciary system, and deciding where the national capital should be located. As I recall, that was the hottest item on the agenda. Why did you persist in pressing for these measures?
Well, at the time that the convention had met, even during the convention, and shortly thereafter during the process of ratification, there was a very strong movement, particularly in Virginia and New York, to call for a second convention. And it was even supported by Edmund Randolph and others, even from Virginia. A second convention would have been very dangerous, and it was initiated in order to seek changes in the Constitution, and in many instances to add some list and enumeration of rights which they felt were requisite, even in a limited government, such as the national government that was just formed. As a consequence, the route to take then to avoid a second constitutional convention was to amend the Constitution by the amendment process through the Congress and then through the ratification of the states with those amendments. It would seek to avert the second constitutional convention, but I also became quite moved by letters from my good friend Mr. Jefferson about the nature and role of a Bill of Rights. And though at first thinking it rather dangerous myself during the convention to add it to the Constitution, I was persuaded that the enumeration of rights, if properly phrased, would not be dangerous to the structure or the operation of the government, but it would help to ease the public mind, diffuse the passions for a second convention, and perhaps eventually inculcate itself into the minds of the American people, that generations to come, they may be so infused with the record of such a Bill of Rights that it may be useful to them, and also in matters of jurisprudence to allow some use of the Bill of Rights when other circumstances of their jurisprudential procedures may be absent of any ruling to make.
Thank you. Mr. Hamilton, General Hamilton.
Thank you.
Excuse me, from my own state of New York. General Hamilton, you and a great majority of the delegates to the convention, as I recall, had opposed adding this Bill of Rights when it was proposed at the convention, at the very end of the convention, aside from the fact that I'm sure everyone wanted to go home by then. You said it was unnecessary, as did Roger Sherman and many others. Can you explain why you and the other framers felt this way?
Absolutely. It was absolutely unnecessary and still is. If it does not say in the Constitution that you do not have a right, then of course you must have that right. I go further and affirm that a Bill of Rights is dangerous, for they would contain various exceptions to those powers not granted. And on that very account, would afford a culpable pretext to claim more than were granted. For why declare those things shall not be done which there is no power to do? It is absolutely, totally unnecessary. Let's take, for example, the right to freedom of speech, if you will. Now, before enumerating these powers in a Bill of Rights, we had carte blanche. As a matter of fact, the press would say pretty much anything they wanted to say. They called, I think, Mr. Jefferson a murderer and John Adams a hermaphrodite. Likewise, the Jeffersonian press accused Adams of being a hoary-headed incendiary. This is, of course, unprosecutable under the Sedition Act, as that is an entirely truthful statement. By delineating in a document a Bill of Rights, you allow the government, or imply that the government has precedent and right to limit your rights. It is absolutely not necessary. We don't need it at all.
I see Mr. Jefferson is about to leap out of his chair.
Imagine my surprise.
Mr. Jefferson, your home state of Virginia has its own very strong Declaration of Rights and Liberties, and other states began their constitutions with similar bills of rights. Do you think the protection of rights and liberties is best secured this way by state governments rather than by a federal government? And if so, why would we need one in the federal Constitution?
Dr. Birkin, if we were to allow all of the states simply to exist solely on their bills of rights, solely by virtue of their own constitutions, well, then I presume that the population in Connecticut is happy and secure, that their constitution grants them the favor to hold their religious opinion as they choose, but then also, by the association of the ecclesiastical laws and the civil authority, binds them to provide a tax to the Congregationalist Church. This was precisely the concern of the Baptists, who wrote me a letter when I was chief magistrate to ask me if indeed they ought recognize the very First Amendment in our nation's Constitution, that they ought to be free to worship as they choose and are not bound to the Constitution of Connecticut solely. I wrote back to them, and I said, indeed, rest you assured that the sentiments expressed in our First Amendment provide that the act of the people recognize that first act in our Constitution, the First Amendment, that the Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, thereby building a great wall of separation between church and state. So yes, Dr. Birkin, I do believe that our amendments in our Constitution should supersede those of state
Mr.
constitutions.
Madison.
It must be added that in matters of natural rights, they are not granted by governments, either state government or the national government. In consideration of the danger to those natural rights, one would expect it to arrive from those governments that are plenary in nature, which were the state governments prior to the Constitution, rather than the new national government, which by its very nature was limited in scope. If one is to consider the nature of bills of rights, only 8 of the 13 states had any reference to a Bill of Rights in any part of their Constitution or in statutory acts. Of those 8, there was no congruence as to what those rights should be. And yet, after the Constitution was proposed and sent to the states for ratification without amendment, there are many that opposed it for a want of a Bill of Rights, when there's really no foundation to think that the danger would arise from the national government that was limited in its scope to national functions. But the dangers to those rights would come from state governments, and that has never been rectified as far as I know.
Mr. Madison, as I recall, many people poo-pooed the Bill of Rights you proposed as said not relevant. They called it a paper parchment. That is, that it had no power, it had no authority, and yet you thought that it was terribly important to pass it. Do you have any response to that claim that it's a mere paper parchment? paper barrier, parchment barrier?
At the point of the conclusion of the convention in Philadelphia, even I had thought it was no more than a parchment. It is a list of rights, and the language itself tends to limit the very right you're trying to expand by its inclusion. It can always be undone by any substantial majority that seeks to undo it. And so as it stands itself, it stands with no authority but for the substance of each of those amendments itself and the implications for other natural rights and civil rights to defend those natural rights, as well as the references to those powers left within the states, as well as rights to the individuals that may not be enumerated in the Bill of Rights. It does have the sense of acknowledging that the government is aware that the rights are there and that the rights preceded the formation of the government itself. It's merely a verbal acknowledgement of that perception.
President Washington,
Madam.
have you actively supported, or when Mr. Madison was proposing this Bill of Rights, were you actively supporting him in this regard? Did you speak out about this? And if not, why not?
Thank you, Madam. I will own to the fact that my initial thoughts align in many respects with what General Hamilton has previously mentioned, and that is that natural law dictates that, of course, unless the people surrender rights or they are denounced specifically in a constitution, then there is actually no real need to enumerate those rights. That said, I will also suggest to you that it became known to me, Madam, that a Bill of Rights would be, what is the term I used it, extremely satisfying to a great number of individuals, both in the government and in the nation. And so I urged that they be enacted promptly, indeed immediately. I will tell you with regard to Mr. Madison, I always find it a rather ironical, if truth be told, that he was in many corners attacked with regard to his hostility towards a Bill of Rights, because if truth be told, has he not been and become a strong proponent of the Bill of Rights as a necessary support of the Constitution? Mr. Madison, of course, did propose a goodly number of amendments, 18, 19, 20 initially, if I'm not mistaken, and then you drafted 12 of them. Of course, 2 were dropped, but 10 remained, and he saw that there was a great deal of debate and hostility amongst members of the Congress. I don't know if this will ring true to all of you in your day and in your time, but the Congress is made up mostly of lawyers, present company included, and they are always arguing about something. So it should come as no surprise that there was a great deal of argumentation and hostility towards Mr. Madison. He specifically, Madam, did ask for my support, and I gave him that support in writing, if truth be told, in May of 1789, at which time I had suggested that a number of the amendments are very important in their own right. Some few others would be more important to men of good character, gentlemen that had a specific interest in it, and that I urged that these amendments should receive a very cordial reception amongst members of the Congress in both houses. So indeed, I did support Mr. Madison.
The nature of those amendments, when the Constitution was proposed to be ratified by the several states, we asked that it be ratified without alteration, without moderation, alteration to the substance of the thing. The response of the Massachusetts ratifying convention was particular because many wanted to amend the Constitution before they would approve it. But each state that had already approved and ratified the Constitution would have to take up the question again each time a change was made by a subsequent state. The several states then followed Massachusetts' example by ratifying the Constitution and proposed amendments that the first Congress would address. Several state ratifying conventions did the same, so that by the time the first Congress was to be formed in 1789, there was a preponderance of proposals by these several ratifying conventions. Over 200 proposed amendments were made. I remember one of the amendments had to deal with the color of the federal judges' robes. And other proposals that were redundant and rather superfluous, and others are rather repetitive. And that is what we tried to do with the Committee of the Whole in the Congress when I proposed it in May and then formally in June of 1789. The Congress is unwilling to address the matter as a sitting body, as a Committee of the Whole, which I recommended, but rather relegated the decisions to the 11 states there. One member from each of the 11 states, Rhode Island and North Carolina, had not yet ratified. And each member of these states then formed a committee of 11, and that was the work that was done in 1789 to propose amendments to the Senate and then subsequently to the states at large.
And I must really give you credit that you took those over 200 proposed amendments and winnowed them down and eliminated repetitions and produced, though it is true, maybe 18 or 19, maybe it was a little longer than we wound up with, but you did do a masterful job.
We did combine some of them into the First Amendment, where they were proposed as separate amendments for freedom of speech and freedom of assembly.
Would you like to suggest who was the most aggravating opponent in the debates, or are you too politic to do so?
I would never wish to cast aspersions on the character of a gentleman who is not here.
Oh, yes, he is.
I opposed the Bill of Rights because it was absolutely unnecessary and dangerous, but it was obvious after a certain amount of time that the Constitution itself would not be adopted unless we had it. So I removed my obstructions.
And I'm happy indeed, General, that you finally saw the light. I will admit that I sat here and have finally heard pronounced publicly to all of you the General's predilection for your own particular opinions. Thank you, sir. But I will remind you, though I was not here during the Constitutional Convention, over 3,000 miles removed, I anxiously awaited that first draft, which was finally sent me by Mr. Madison. He knew well that I was not in favor of this Constitution. I thought the Articles of Confederation were a venerable fabric. They ought not to be tampered with.
Completely
However, sir,
inefficacious.
when I received that draft, rest you assured, I was indeed captivated by this Constitution. Citizens, the shortest document of its kind in human history, creating a government to check its own power, and of the three branches, which branch the most influential? The legislative branch. That branch elected by whom? The people. And therefore, if elected by the people, the entire government allowed to exist through the approbation of the people, as Mr. Locke would suggest, well then, ought not the people be protected directly in their inherent rights, not with favors granted by their government, but their government serving to protect and defend those rights given to them, not by any government, not by any ruler, but those rights given to the people by nature and nature's God. And therefore, General, I was the one to suggest to Mr. Madison a Bill of Rights is what is necessary, required by all people to protect them from their government. Initially, he wrote me back, said they're all inferred, as you just sat here to pronounce yourself. I ask you, sir, as I wrote Mr. Madison, I ask the people, are we then to rest upon inference on such an important subject as the inherent rights of man?
Mr.
If
Jefferson.
I may. Oh, sorry. I do get a chance for rebuttal.
Yes, you do, but
Mr. Jefferson, you must own that in a Bill of Rights, if you allow the government the precedent and the right to delineate those rights, then you imply they are able to control the inherent rights, where the rights exist without that.
But it's not the government that's writing the rights, it's the people through the representatives.
Thank you, sir.
And though you have been an obstacle, perhaps in your opinion, adverse to the Bill of Rights, sir, because you are not in Congress, I would not consider you my worst opponent. I could give that credit more to Theodoric Sedgwick. And
Mr.
Sherman.
Madison, can I ask you one? I can name some people who really gave you a very difficult time. You wanted the amendments added to the body of the Constitution itself. It was, as I recall, Roger Sherman who put forward most strongly the argument that they should be put in as a series of amendments to the Constitution. Do you regret that now, or do you think that that was probably a wise decision?
Initially, in considering fundamental law, with the ratification of the Constitution, it renders the Constitution fundamental law rather than one proposed by legislatures and thus becoming legislative act or statutorial, which can be changed by any subsequent legislature thereafter. The fundamental law relies upon the acquiescence of the people at large, not as a consolidated government, but in each in their respective states. The nature of the inclusion of the rights so assessed as we had done with the habeas corpus and bills of attainder and references in that respect were included in the Constitution. We'd hoped that we might be able to also include it, rendering the whole document fundamental. Mr. Sherman was concerned, as was Mr. Johnson from Connecticut and Mr. Ellsworth from Connecticut, that the ratified Constitution in its original form ratified by the several states would then be changed and would not be the document that the states had ratified to begin with and wished to append them to the end. I was fearful that in offering amendments and appending them to the end of the Constitution, that they would find themselves less valued, considered perhaps lesser than the Constitution itself. And that's why I opposed putting it at the end of the amendments. But I suppose as the people's consideration of those amendments have been, and the subsequent amendments, the 11th and 12th Amendment, they didn't take on the same importance as the articles themselves of the Constitution.
As I recall also, the 12 amendments were sent to the state legislatures for ratification, and the first two were not accepted. That is, they were not ratified. Do you have any explanation for why this is so? Anyone want to suggest why there was such strong opposition or across-the-board opposition to these two amendments? One was about the representation, number of representatives in the Congress, and the other, I believe, was about salaries. Why were those
Congressional salaries.
Congressional salaries. Why were those not welcomed by the states?
There was considerable argument at the time of the convention itself and shortly thereafter about the representations in Congress and the number of constituents per representative. It had to deal with the total number of members in the House of Representatives, which was apportioned according to the population, whether it should be a fixed number and allocate the number of constituents to a fixed number, or to allocate the number of constituents to a representative and let the legislative branch, the House of Representatives, grow in number as the population would grow, which is ultimately what was done. But there are still some who advocated that there be fewer number of constituents per representative under the assumption that they would be better represented by having fewer people per representative. And so it was one of the proposed constitutions by several of the ratifying conventions to reduce the number of constituents per representative. But when sent to the states themselves did not ratify it. Some did, but not enough to make it 9. And some of the states were jealous of increasing the number of constituents per representative, might have the effect of increasing the amount of representation in the larger states and decreasing it in the smaller states as a consequence.
Can I ask you all just to comment not so much on the meaning of the rights as on the political implications of passing the Bill of Rights? That is was there any strictly political gain or loss to any group by passing the Bill of Rights? We call that today interest politics or party politics.
Madam, I think that the interest was in nothing less than acting as a buttress, a support of the Constitution itself. I had mentioned earlier that there were a great number of members of Congress, indeed citizens of the nation, that would have found the Bill of Rights extremely satisfying, are the words that I used. So let us not forget that it served to bolster the Constitution itself. It is interesting because a moment ago Mr. Madison was speaking about whether or not certain items would you asked whether the amendment should be part of the Constitution or indeed amendments themselves as such. If they would become part of the Constitution, as he intimated, the Constitutional Convention would start yet again. And I am not sure how many of you understand, had we done such, how much that would have put the Union at risk, without question. I was the presiding officer of the Constitutional Convention in Philadelphia City in 1787. And you cannot, unless you were there, enough appreciate the degree of faction, the degree of dissension that existed at times during those deliberations. Wealthy states versus poor states, free states versus slave states, large states versus small states, northward states versus southward states. And so to set up a confabulation yet again on the same subject, indeed that would have put the Union at risk.
In those days, in the days prior to that, under the Articles of Confederation, in the Confederational Congress, I came first to know Mr. Madison, and we at that time saw eye to eye. Well, literally, we're just about the same height, right? But Mr. Madison spoke out against the system we had at the time as the anarchy of our system. I don't know if you can conceive what it was like. 13 separate petty countries. You couldn't spend New Jersey money in Pennsylvania or Pennsylvania money in New Jersey. There were taxes for going across the border of each and individual state. One state, it only took one state to stop any progress in the Congress, and that state was usually Rhode Island. I don't know if you appreciate a Congress that is absolutely stalemated and will not get anything done.
It was often New York also.
Well, it was so stated as nothing more than a firm league of friendship, if truth be told. And as you remember, General, I had writ at the time that this is a government, a formation of a government, the Confederation Congress, that was constantly set upon crutches, teetering, ready to fall over at any minute.
But there was a document that established our national sovereignty as a nation and allowed us to go forth as a nation that preceded both the Articles of Confederation and the Constitution. The Declaration of Independence, the ultimate constitution of any state. In it, we established our right to national sovereignty, our right to make treaties, our right to enact war, our right to collect taxes. All of that firmly established in 1776. Thank you very much, Thomas Jefferson. Let's give him a round of applause for that.
This is a historic first.
I thank you, General. I thank you. I cannot deny that though we have disagreements, and Madam, if you will, your comment about how politically our amendments are want to affect our nation reminds me that in the midst of our differences of opinion, as Americans we know, a difference of opinion ought never be a difference of principle. And therefore, General, you and I have both understood well the principles of drawing 13 individual nations together under our compact. And yes, our Declaration of American Independence is that compact. It rests in the very last sentence of our declaration. That oath taken by all of the delegates, the 56 who signed their names, quote, on behalf of this declaration, with a firm dependence on divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. So I thank you, General, for that recognition. And ma'am, if there is any political referral to what our amendments provide, it is that the people may be ensured in their right to disagree and to continue to make an effort to improve our government and to recognize, as I've often said, that very first line in our Constitution, that, as you know, General, inscribed by Mr. Morris, one of your own particular political platform, a Federalist. But I must admit that very first line is want to say it all for now and the future. It is simply, we the people, to help us to understand in the improvement of our government one generation after another that as a child of 14 cannot wear the same clothes at the age of 40. Our laws and institutions must grow as we grow as the people.
Mr. Jefferson, you bring up the beginning of our Constitution, which begins, "We the people of the United States." I'm certain you're all well familiar, but perhaps you are not so familiar with the first draft of our Constitution, which began, "We the people of the states of Connecticut, New Hampshire, Massachusetts, etc., etc., sending a very different message to the world than "We the people of the United States." Make no mistake, the eyes of the world are upon us, and we are the great experiment. We need all the great ideas we can get. Now, it has frequently been remarked that it seems to be reserved to the people of this country, by their conduct and example, to determine the truly important question whether societies of men are capable or not of establishing good government from. Are we fit no more for the rein and the spur, or can we indeed govern ourselves? We have fought side by side to make America free. Let us struggle hand in hand to make her happy as well.
I declare, Mr. Madison, he is a colossus, is he not? I declare he is a host unto himself. He would not even need a party.
I may respond to your initial observation, Dr. Birkin, that the amendments themselves proposed, 12 proposed, eventually to the several states, and those which are ratified, and not all states ratified all of those amendments, but sufficient number of 9 ratified 10 of them, the 3rd through the 12th amendments proposed. There's nothing political to be gained unless the First Amendment had been done. The Second Amendment, to which you had alluded to the compensation of members of Congress. And there was some fear that when the first House would meet, that it would vote during its session and without a previous election to take place, that the members of Congress would vote to lower their salaries in order to ensure that those of lesser means would not be able to serve in the House of Representatives. And because of that fear, many of the states did not ratify that Second Amendment that was proposed. It may be that subsequent from now, and you may be better a determinant than I, that it may be subsequently ratified years from now, but it has not yet been ratified in my estimation. The proposed amendments also were political, only in that it gave substance and comfort to the public mind that was ill at ease in their sense of the legitimacy of the government that they had created. But as to particular amendments, there was no particular advantage to any one part of the country, any one section of the country, any one group, any one faction in the country. So in that respect, they were themselves apolitical.
Thank you. I want to ask a question about the future as you see it. Do you envision more amendments to the Constitution beyond the 10 that have been passed? And if so, are there any that you in particular would like to see proposed?
Madam, if you will allow me, I would suggest that none of us are soothsayers, nor are we prognosticators. That said, I caution my fellow Americans, with whom the power resides, we should not take the spirit of innovation lightly with regard to the Constitution of the United States of America. I urged the gentlemen in my day and time with regard to the emendations that were being considered that they think seriously about the alacrity, the speed with which they were rushing towards this Bill of Rights. And I said such because I was greatly concerned that this spirit of innovation that I mentioned would not allow the effects of the Constitution to sit and be realized as it was written. And I urged them to allow things to play out a bit before this process took place. It is that same spirit of innovation that I would urge you all to be very mindful of with regard to any possible amendments in your day and in your time.
It might also be said that in the amending of a constitution, as the good general had pointed out, it is to be guarded against such an alteration of the structure of government and the operation of government, which the amendments should seek to achieve. And as the good general mentioned, that it cannot be undertaken lightly without consideration of the many, many ramifications of any such amendment. We've had the 11th Amendment added after the case of Chisholm versus Georgia. And the 11th Amendment seems to reinforce that constitutional decision in the case, I believe, of Chisholm versus Georgia, if I am correct in that. And it helps to solidify the nature of the first article in regards to relationship of states and obligations of contracts, I believe. And this kind of amendment is a reinforcing amendment of that which is already stated in the Constitution and helps to reinforce it without causing any major alteration either in the operation of the government or the structure itself.
So, Mr. Madison, those proposals from the states at the ratifying convention that proposed actually to alter the powers of the government, for instance, to remove the right to tax, to remove the right to regulate commerce. I mean, there were proposals to, in essence, eviscerate these powers. Those were the ones that you did not put forward, is that correct? I mean, your concern was the preservation of the Constitution.
The work of the Constitution was the product of many heads and many hands, many reasoned gentlemen, well-versed in the history and the annals of mankind, well acquainted with the operations of government and well situated and within their own states to know the political circumstances there. One cannot calumniate against those who would wish to advance ideas which I thought might be inappropriate. Mr. Monroe in Virginia was one who wished to remove the power of taxation, as an example. Mr. Mason, Colonel Mason, advanced certainly the idea of a Bill of Rights, but also other structures of the government. Mr. Ellsworth, Mr. Jerry in Massachusetts was objecting to the relationship between the executive and the Senate. So there are many men, well-reasoned, who gave objections to the Constitution, and these were reflected in the proposed amendments over the 200. But I think reason and moderation on my part, as a member of that 11-man committee, and the committee itself, did adjudge that those alterations would have been inappropriate, if not dangerous, to the operation of the government.
Ma'am, I would say, in recognition of what even more this evening convinces me of the most luminous mind I have ever known, the mighty Madison, that indeed further improvements may be necessary in logistics and procedures within our Constitution, that we should question whether it is indeed that individual that receives the second highest number of votes ought to then become vice president. And citizens, let us not forget as well, the majority of the four gentlemen upon this platform are well familiar with that most abominable institution, which we must realize, as God is a just God, he himself cannot but abhor. I would hope that may be attended to.
I believe heartily that Constitution should consist of general principles only, as they must be permanent, despite what Jefferson says, and cannot calculate on a possible change of circumstance. As to amendments, there are many powers that are implied within the Constitution, such as a right to have a bank, as other things.
Where in our Constitution does it make any statement
Gentlemen,
of the right to have a bank?
Thank you, General Washington.
Gentlemen, please, if you will allow me the last word, madam.
Yes, indeed.
You know, in every situation, there is content and there is process. We have spoken a great deal about content this eve. If you will allow me just to mention that our Declaration of American Independence, which was the promise, our Constitution of the United States, which was the delivery of that promise, and the subsequent Bill of Rights, none of it could have been achieved without the spirit of mutual concession and amity. And I would urge you to keep that in mind. I touched on it very briefly. We will not succeed as a nation if we allow faction and division and, dare I say, political party to get in our way. If we set all of that aside, there is nothing that we cannot accomplish as Americans. I was touched to learn that the motto of the nation has changed. It is a lovely sentiment in your day and time. It is, "In God we trust." That is not the motto of the nation when it is formed. The motto at the time that we become the United States of America is the Latin phrase, "E pluribus unum." Out of many, one. We remain your humble and obedient servants.
Thank you very much, gentlemen.